Hi students. In this video we're going to continue our discussion of the 14th Amendment and the Equal Protection Clause, but by taking a look at how it interacts with the First Amendment and the Free Speech Clause. In particular, we're going to be looking at religious exemptions that are requested by cake bakers, photographers, things like that, when they're asked to bake cakes or to work in a same-sex couple and a same-sex wedding. So we've got cakes, we've got bakers who are just trying to decide whether they are or not going to bake a cake. And in particular, we're going to look at cases where the bakers decide not to bake the cake and see what we should think about those cases. Do the free speech rights of the bakers win out, or do the equal protection rights of the consumers win out? Now, the first case we're going to take a look at is Cryer versus Sweet Cakes. This is from 2015, and it was a case that took place in Oregon. It actually never ended up making its way all the way to the Supreme Court, but it's a case that John Corvino is going to talk about in his paper, and that's why I want to talk a little bit about the details here. So the facts are that in 2013, Rachel and Laurel Bowman Cryer asked Aaron and Melissa Klein, the owners of Sweet Cakes by Melissa, to make them a wedding cake. Although the Kleins had served the Bowman Cryers in the past, they refused to make them a wedding cake and cited religious objections to doing so. So the thought here is that Sweet Cakes makes a bunch of different foods, pastries, that sort of thing, and that they had served the Bowman Cryers, so they didn't refuse to serve anyone maybe who was attracted in people of the same sex, but rather their objection was to baking a cake for a same-sex wedding. In doing so, Oregon found that they had violated the Oregon Equality Act, which prohibits businesses like Sweet Cakes from discriminating on the basis of sexual orientation. Now, it's worth noting that businesses like Sweet Cakes are not prohibited from discriminating on other bases. So, for example, a business like Sweet Cakes is not prohibited from refusing service to KKK members, since KKK members are not a protected class, right? The thought is that one's racial status, one's sex, maybe nation of origin, some other things like that are going to be protected classes, so you can't discriminate against people based on those reasons. But you can discriminate against people based on other reasons, right? If they're members of the KKK, you could not serve them, and that's because the KKK members haven't been discriminated against in the past in some sort of problematic way. So the central legal question in this case is whether business owners who have the sincerely held religious belief that same-sex marriage is wrong are those people exempt from Oregon's law that prohibits discrimination on the basis of sexual orientation. So we've got this law, can't discriminate based on sexual orientation, but when we have a cake shop owner who thinks same-sex marriage is wrong, are they able to say, no, even though I will happily serve you a bunch of other items on my menu here, I'm not willing to make you a cake? Is that kind of exemption allowed? So that's something I want you to spend a little bit of time thinking about right before we move on. What do you think about this case? Should business owners be allowed to be exempt from this law, and especially right in the cake baking case, or not? If we ask how the court ruled, and no, I don't have the special image of the court here because it wasn't a Supreme Court case, so I want to be clear about that. But the highest court that ruled on this case, ultimately decided that business owners who have the sincerely held religious belief that same-sex marriage is wrong are not exempt from Oregon's law that prohibits discrimination on the basis of sexual orientation. So in Oregon, at least, they decided, nope, this is a law. Your free speech rights are not going to trump sort of the equality rights of the couple in this case. Now, in response to this and other cases very similar to it, John Corvino writes an article for the What's Wrong blog. And I point it out only because the blog was started at CU Boulder by one of my professors there, and Corvino's piece that you read here isn't, or will read, it's not a famous, really big, important article, but it is a nice sort of article to get clear on maybe what our options are and how we should think about balancing the rights between cake shop owners or photographers and same-sex couples, on the other hand. So what's Corvino's thesis? What Corvino is going to do in this article is propose 3 different ways that we might balance the equality interest of same-sex couples, like the Bowman-Cryers, with the liberty interest of religious people who oppose same-sex marriage, like the Kleins, for example. And in the end, Corvino is going to argue that although we should allow religious people who oppose same-sex marriage to publicize their opposition, we should not allow them to refuse to bake cakes for same-sex couples. So we're going to survey those sort of 3 options and look at sort of like what they might have going for them, what they might have going against them. Option 1. The first option for Corvino is to fashion anti-discrimination law in such a way as to exclude businesses or services of certain types or sizes. So on this view, if you're sufficiently large, or if your business is of a certain type, then you can't discriminate against various groups. But if you're sufficiently small or a certain kind of business, then you could discriminate potentially. So he says one such proposal would permit businesses of 5 employees or fewer to refuse service on account of sincerely held religious beliefs, when those to whom they are denying service can obtain it elsewhere without substantial hardship. So the thought here is that if a small bakery wants to deny service to a same-sex couple on account of some sincerely held religious beliefs, then they can, as long as that same-sex couple can get a cake somewhere else nearby without too difficult a time. Now, of course, there are some, details we might wonder about. So why is it 5 employees rather than 6? Why 6 instead of 7? What number of employees? How small do you have to be in order to be able to get an exemption? Another thing we would have to ask about or think about is why would we only privilege sincerely held religious beliefs? What about sincerely held moral beliefs? Presumably you could have a moral belief that's not grounded on some sort of religious view. So, and in fact, in another paper, Corvino sort of argues that religious belief shouldn't be get some sort of special status as opposed to moral beliefs or things like that. I'm actually inclined to agree with him on that point. And then finally, he sort of says, well, what's going to count as a substantial hardship? That's a question that we would have to sort out. So is it if there's another cake shop nearby, how close would it have to be? Is 10 minutes too far? Is 20 minutes too far? An hour? So, and then what if they don't make the exact same kind of cake, right? So maybe you've got, you really want a 5-layer cake, and this is the only place within 1,000 miles that makes 5-layer cakes, but there's a place down the street that makes 4-layer cakes. Is that going to be too big of a hardship? Should you be able to get the 5-layer cake, or should you have to settle for the 4-layer cake? On to option 2. So Corvino thinks, option 1, I don't think that's sort of the right solution. There's too many problems we'd have to sort out. Option 2 maybe is better. So we could legally prohibit discrimination, grant religious and perhaps other exemptions, but require business owners who take advantage of the exemptions to post their position publicly in order to give prior warning to same-sex couples. So one worry with the previous policy, for example, is that same-sex couples might have no warning that they're about to enter and ask for a service that someone's going to deny them. And there's something offensive and hurtful about that. And so Corvino thinks we need to give them some warning. So if you're going to if you're going to give religious exemptions, I should say, then you need to warn customers that you'll be using those exemptions. So the thought is for the clients, complying with the law is going to require them to post a message on the website, maybe on the front of their store, that looks like the following. it would say something like this: we welcome a diverse group of customers for a wide variety of baked goods. However, we also believe in a traditional definition of marriage as the union of one man and one woman. Accordingly, notwithstanding the Oregon Equality Act, we do not provide cakes for same-sex weddings. So the thought here is that if you're going to make an exception, you've got to publicize that to let people know so that they don't come in, ask for a cake, and then end up being refused. So that seems like a better solution if you're going to allow exceptions. But let's move on to the final option, option 3. Option 3 doesn't allow exceptions. Right? It says we legally prohibit discrimination. We do not grant religious exemptions, but we do permit business owners who object to same-sex marriage to post their position publicly. So here we're emphasizing the sort of speech element. If bakers don't want to speak by engaging in, participating in, promoting same-sex marriage by baking the cakes, maybe they feel like that is in a way speaking in favor of the union. We just want to emphasize their ability to say explicitly that they don't support those unions. So for the clients, complying with this law might involve them posting the following message on the website and or on the front of their store. So again, this is totally optional. He's not saying you have to post a sign like this. But if you hold these views, you would be allowed to. It would say something like this: we comply with all applicable laws, including laws that prohibit discrimination on the basis of sexual orientation. We thus provide cakes for same-sex weddings when requested to do so. However, we also believe in a traditional definition of marriage as the union of one man and one woman, and we personally oppose same-sex marriage. Now, Corvino is quick to point out that this is already an option, right? So, in a way, he thinks, in a way, we don't have to change any laws in order for this to be the case. We would just be encouraging, right, cake shop owners to publicly express their views. And in a way, if they're worried about speaking by baking the cake, then we should just emphasize that they can sort of simultaneously say this thing that makes it clear that although they bake this cake, they don't actually support the marriage of same-sex couples. He says that this kind of law would protect the cake shop owners, protect their freedom of speech, and make it less likely that they would have to serve same-sex couples, right? Presumably, if a same-sex couple saw this sign, they might think, well, even though I could get the cake here, I don't want to because I don't want to support this sort of business. And so they would, maybe in most cases, maybe all cases, not have to bake cakes for same-sex weddings because same-sex couples wouldn't go to them in the first place. But the other benefit that this option has is that it ensures that same-sex couples can procure the wedding cakes, photographers, etc. that they want, and it helps them identify which businesses share their values. So the thought is, at the end of the day, we want to give people equal protection of the laws, and that, for the same reason, we think that laws that prohibit black people from eating in certain restaurants, those are problematic. Analogously, we should think that laws that allow some cake shops to refuse to serve same-sex couples wedding cakes, those are problematic on the same sorts of grounds. And we want to be, why are they problematic? Right? Well, black people should be able to get food and eat out at a restaurant or something. And the thought here is, well, same-sex couples should be allowed to get wedding cakes and have access to those things. And so we're giving the protection there, also helping them, in this case, same-sex couples identify which businesses share their values, giving them options, right, and information that's valuable. Of course, there are objections to this option, right? The obvious objection to this option is that it's going to force business owners to endorse or participate in same-sex marriages, even if they sincerely believe that doing so is wrong. So you might think of the KKK member who wants a cake for their KKK party. I call it the KK cake. And we think, surely a baker shouldn't have to bake that cake, right? If they don't agree with those sorts of views, they shouldn't have to bake that cake. But here it seems like we are requiring them to endorse or participate in, support for, provide this cake for this event which they do not support. And that seems like there's something problematic about that. In response, we can sort of say two things. So on the one hand, we have to ask this question, right? When we bake a couple's wedding cake, does that really count as endorsing or participating in their marriage, right? What wedding have you gone to where you've sort of known who made the cakes in the wedding? I would venture to guess 0. You have no idea who created the cake at that wedding, and so it's not like they're going to really think anything about you based on baking some cake for a wedding. But let's say that it does, right? Let's say baking a wedding cake, even if nobody knows about it, you are sort of participating in this. You're complicit with this thing that's problematic. Maybe you didn't rob the bank, but you drove the getaway car, and nobody knows that you did, but you're still sort of involved in what you see as this wrongdoing. It's worth noting, right, that we don't seem to mind forcing business owners to endorse or participate in interracial marriages. So what's the difference? Right? The thought is, even if this is kind of endorsing or participating in, we would certainly not allow a cake shop owner to refuse to bake a cake for an interracial marriage. And so if we wouldn't allow them to get an exemption based on that belief, why would we allow them to have some exception in the same-sex marriage case? I think that's a really interesting question, and I think at the end of the day, it comes down to an issue about what beliefs are sort of reasonable to have. We don't think it's reasonable to think that interracial marriage is wrong or morally problematic. But at least in our country right now, as I'm making this video, we seem to think, or at least there's a large group of people in the country that think that it is kind of reasonable to believe that it's wrong, or that you shouldn't have to bake a cake for a same-sex couple, that there is something wrong with being complicit in promoting those marriages or those unions. And maybe that'll change, right, in time. But I think that's maybe one of the issues. And to what degree do we want the law stepping in and saying, like, here's what it is reasonable to think, and here's what it's not reasonable to think, that sort of thing. All right, I want to finish this video with a discussion of a case that did make it to the Supreme Court: Masterpiece Cake Shop versus the Colorado Civil Rights Commission. This case was decided in 2018. It was a big deal because it was exactly, in many ways, exactly the same kind of case as we looked at in Cryer versus Sweet Cakes, but this one did make it, in fact, all the way to the Supreme Court. In this case, the legal question was the same. I'm going to put it here in a slightly different way, but essentially it's the same question as before. So in this case, it was a case from Colorado. Does the Colorado Anti-Discrimination Act require bakers to bake cakes for same-sex weddings, even if that would require them to violate their sincerely held religious beliefs? That's the question. So we might ask, well, what's the Colorado Anti-Discrimination Act say? I've got that here on a slide. So, it is a discriminatory practice and unlawful for a person, directly or indirectly, to refuse, withhold from, or deny to an individual or a group, because of disability, race, creed, color, sex, sexual orientation, marital status, national origin, or ancestry, the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of a place of public accommodation. Okay, so what is this saying? It says if you have a public business, you're accommodating and serving people, then it's discriminatory and unlawful, right, to refuse or withhold treatment or service to some group based on one of these features. And so one maybe straightforward reading, right, says that, well, in this case, what Masterpiece Cake Shop did was it refused to perform a service for an individual or a group of individuals because of their sexual orientation. And as a result, what they did was unlawful. All right, so that's the question, right? Does this act require bakers to bake cakes for these same-sex weddings? And again, that's something I want you to think about, right? might be asked questions about this. What's the tension here? Well, if it's not sort of obvious, the thought is the tension is between, on the one hand, the free speech rights of the cake bakers, who don't want to. They feel like they're being compelled to speak in a certain way by providing this item for the same-sex couple. On the other hand, we've got the Equal Protection Clause that says we need to give people equal protection under the laws. We shouldn't allow discrimination on the basis of same-sex attraction. And so what are we going to say here? Does the free speech right win out? Does the equal protection right win out? So how did the court rule in this case? The opinion in this case was actually 7-2. So a large majority, not 5-4, as in some of the other cases. But again, it's authored by Justice Kennedy, again, one of these moderate justices, sort of in the middle between the more liberal and conservative factions on the court. And it ended up ruling in favor of Masterpiece Cake Shop. And you might think, oh, well, I guess it said that the free speech right wins out. But that's not really true, because in ruling that way, the court ended up dodging really the central legal question in the case. So instead what it did was it based its ruling on the fact that the Colorado Civil Rights Commission expressed hostility towards religion when it evaluated Masterpiece Cake Shop's owner, Jack Phillips's reasons for deciding not to bake a cake for Charlie Craig and David Mullins' same-sex wedding. So really what they looked at was they said, after Masterpiece Cake Shop and Jack Phillips refused to bake this cake, Charlie Craig and David Mullins, wrote in this, complaint, and Jack Phillips had a chance to respond to it and sort of explain his reasoning. And when the Colorado Civil Rights Commission took a look at Phillips's reasoning, they said, well, you're part of this religious group and religion's ridiculous. That's the sort of idea. And so, no, we're not, giving you an exemption. And so what the Supreme Court ended up doing was saying, like, I'm not going to decide one way or the other on whether or not cake shop owners should be allowed to refuse to bake cakes for same-sex couples. Instead, what I'm going to focus on is the fact that the Colorado Civil Rights Commission violated the free exercise clause of the First Amendment. So according to the court, the problem was that the Colorado Civil Rights Commission violated the free exercise clause of the First Amendment and ended up sort of not saying whether the free speech rights of the baker or the equal protection rights of the same-sex couple won out. Okay, so we will have to wait and see on that. We don't have an answer now how to balance these free speech rights against the equal protection rights. But that's something that you should be thinking about, right? Having seen this video, thinking about how would you rule in these kinds of cases? What do you think the law says? How do you think justices should think about the law when they're faced with sort of clash between free speech rights and equal protection rights? All right, that's it for now. Have a good one.